And welcome to the week 6, chapter 6 video lecture. This will be on prosecutors, which is certainly my specialty area. I spent 23 years as a public prosecutor, and I know the position well. So let's go on and figure out what we're going to learn about prosecutors. First, we're going to discuss the two major characteristics of prosecutors in the United States, then describe the three most important entities in the federal prosecution. We're also going to identify the three somewhat overlapping agencies involved in prosecuting in state courts. We'll see that kind of interesting. 4, we're going to explain the major factors affecting the work life of assistant district attorneys. These are people who work as deputies under the elected official, who is the head law enforcement officer for the jurisdiction. And then we're going to analyze the principal factors affecting prosecutorial ethics. We'll see that there are many ethics upon which the prosecutor must obey, and for very good reason. They have a tremendous amount of power, and they can easily violate these ethics and cause very great inequities and injustices to occur. And then we're also going to outline two major examples of the expanding domain of the prosecutor, because as it turns out, more and more power is being given to the prosecutors over time, as we'll see. Let's look at the origin of the public prosecutor. First, we went from private to public prosecutions way back in earlier English times, brought over to the United States, of course. We used to actually have it so that private citizens would bring an action and then have to prove up the crime to facilitate their private vengeance through the government-controlled court system. So the government would sort of give them a court, but they had to come in and prove up a case as private citizens. This was very true in even ancient Roman times. Went through the courts in medieval times. If you wanted to, have vengeance for the fact that one of your relatives was killed by another clan, well, you proved it up in court. You asked for the death penalty against the accused, and you did all the work yourself, essentially. They gave you a court, but that was it, and the court had the power to have someone hung as a consequence of the murder, but that's about it. And then we went to public prosecutions rather than private. There was a lot of concerns over due process, whether a person got a fair trial, a lot of problems with whether it is always right to prosecute someone. Some cases shouldn't be prosecuted, at least not in a criminal sense. There may be civil remedies that are available, and it's just not a good idea, public policy-wise or otherwise, to actually put someone through the criminal system when let's say someone spits in somebody's face. Very insulting sort of thing. It's actually a battery. It could be criminal, but why use up all the criminal resources on something like that? Bring in a jury of 12, to decide the case. Waste all those people's time when the victim can sue the perpetrator, both for compensatory damages and for punitive damages for what they did, and sort of wreak their own private vengeance that way, and save everybody a lot of money, and have a much lower standard of proof, because civil cases need much less proof than criminal cases. Okay, so we basically went from private public prosecutions to public prosecutions, and that came into being pretty much in the later part of basically around 1500s or so, 1600s. We're starting to get into public prosecutions, generally speaking. There's also quasi-public prosecutions. We have sort of a prosecution outsourcing model where we actually would outsource the prosecution duties to someone outside of a public agency. We sometimes have a part-time prosecutor model that is involved in, we have someone who does other things, maybe a private attorney, and we bring them in part-time to prosecute cases and decide on what will be prosecuted. So sometimes we have a quasi-public type prosecutions that are out there as well. The role of the prosecutor, let's look at some of them. First, one thing that the prosecutor has is very broad discretion. Broad discretion in deciding whether or not the evidence that they have before them is sufficient to prove the case. So that's the first question they have is, do I have sufficient evidence to prove the case? They have broad discretion in deciding whether that's true or not. And by law, at least in California, they only have to have probable cause to believe someone committed a crime to file against them. You do not have to have proof beyond a reasonable doubt. That can sometimes be developed before the trial. And so they decide on whether it's appropriate to bring somebody in, have them arrested, brought into the court system, and prosecuted or not. So there are limits on that discretion during trial. The judge will often have the discretion to do things during the trial, not the prosecutor. And there are limitations of the Constitution on what decisions can be made during the trial and up until the trial. There's also prosecutorial misconduct that can happen because of this broad discretion. For instance, they may have discretion to decide on what evidence they have to give to the defense by way of discovery, but they also have legal duties to give over any exculpatory or potentially exculpatory evidence to the defense. And so they may use that discretion in deciding that certain evidence is not exculpatory or potentially exculpatory, and they may essentially be guilty of prosecutorial misconduct and found to be such. And we'll find later on that very often, if a prosecutor does not give over evidence to the defense, it's because they don't want them to have it, because it will help the defense to win the case. That's true prosecutorial misconduct. Essentially everything other than a very small amount of items that can by law be kept from the defense should be given over to the defense regardless. And when I was a prosecutor, I gave over everything. I was actually accused of giving so much information to the defense that I was accused of hiding the information in all the stuff that I gave them. It was actually, as far as I was concerned, to be a bit of a compliment, because I would tell the judge, well, judge, you can't say I'm not giving them everything. It's their duty to go through all that and figure out what value it has for them, but it's my duty to give it to them. That kind of thing. All right, so in charging decisions, of course, that's entirely within the discretion of the prosecutor. The judges have no such discretion. Defense attorneys have no such discretion. So you can see only the prosecutor will decide on what charges will be filed in any given case. They have total discretion. No one can touch them. And even if they file charges that are not even substantiated by the evidence, they're also completely immune from civil prosecution for abusing the process by filing charges that were not substantiated. And the reason why we do that is because we don't want prosecutors worrying about being sued because of their decisions. If they just make a mistake, they don't want an honest prosecutor to be sued because they made an honest mistake, essentially. Because if we allowed that to happen, we'd have prosecutors thinking twice about whether they want to file or not because they're worried about their own finances. And that's not what we want. We want them to have the discretion, but we want it to be pretty much unfettered in deciding what's the right thing to do. We hope that they will do it with good ethics and so on. So there's also an overview of focal concerns theory. Now, this theory really doesn't relate so much to charging decisions, but it does have to do with sentencing decisions. Normally speaking, what goes into sentencing decisions of a prosecutor, which is basically what sentence the prosecutor is going to argue for, because again, sentencing is up to the court, not up to the prosecutor, but the prosecutor will push for a specific sentence. And when they do, they look at several factors. One is blameworthiness, the other is protection of the community, and the last one is certain practical constraints and consequences of the actual sentence itself and deciding on what they're going to ask for. Okay, blameworthiness, of course, has a lot to do with Yeah. Do we have a career criminal here? Someone who we're going to have to deal with, later on? Someone who maybe needs more treatment because they just have a criminal mind and they just think that that's the kind of criminal conduct is perfectly okay. That kind of thing. How heinous was the crime? How cold of a heart do we have of a person here? Does this person have any conscience whatsoever? And that sort of thing. Protection of the community, of course, has much to do with whether we think the person is going to be back and doing this again. Because if we think they are, we're probably going to want to get a much higher sentence on them because first it keeps them off the streets for a longer period of time, but hopefully it will eventually, economically disincentivize them to continue with more crime because it's just too costly in terms of their life. If you give it 15 years every time you do something, you get caught every two or three times that you do it, you're not going to be doing it very more times because you're going to spend your entire life in prison if you do. And then the last one is that these practical constraints has to do with what it costs to put people into prison. It's like $49,000 a year to keep one prisoner in prison these days. So how much do we want to give this person based on what it costs to do that? And there's other social costs involved as well. We may take somebody out who's a father, for instance, and a provider for a family. Now we may have to, that family may be on welfare as a result. So there's social costs involved as well. But the theory here is that there can be a significant biases in the system when it comes to sentencing based on race, ethnicity, gender, and age. Based on the fact that there are stereotypes that have been created in the system for certain people. Let's say a black person. Let's say, well, black people. Let's say there are more black people in prison for crimes than white people. So we have a stereotype that we have more of a problem with black people than white people. That's sort of a stereotype. By the way, that's not true, but that's the stereotype that goes on out there. And so you can see the problem when that kind of thinking gets into sentencing concerns, both in terms of the prosecutor and of the judge. That can be serious matters. And this theory is that these stereotypes that have come into play, both in terms of race, ethnicity, gender, and age, all factor in because we don't know everything about this defendant. We don't know exactly how he or she is going to react in the future, and so we tend to put them in a little cubbyhole based on stereotypes instead of actually trying to figure out who this person is. It can also, this theory can be also applied to charging decisions because, maybe we might let somebody go without a criminal prosecution because we think that it's something that is not going to happen again. There's great remorse for what happened. We could take care of the victim through civil actions, that kind of thing. That might not be the case for someone of a different race or different gender or different ethnicity or different age. Okay, so a very old person, for instance, we're going to treat them probably much differently than a very young person, as an example. Okay, now also we have an issue of the fact that prosecutors are very decentralized. It's not unusual, and in California this is actually true, that we have state prosecutors. That's the Attorney General's office. They are at the actual head law enforcement officers for the state. Whatever they say goes, but they typically don't prosecute a lot of cases. Most cases are prosecuted by the county district attorneys. They are a separate elected official, and they make most of the charging decisions on most cases. Attorney generals will get involved if they want to, and they can override whatever decision is made by a county prosecutor, and they can come in and prosecute a case or fail to prosecute a case, or just take up a case and say they're taking it. And the local prosecutor is out of business on that case. But there's also municipal prosecutions that are available. That means that a city can have a city prosecutor, So you'd have a city prosecutor, a county prosecutor, and a state prosecutor, all of which are separately elected or appointed positions that that all have their own powers. And so now you're getting, depending upon which prosecutor you get, you're going to get possibly a different way that things are prosecuted, because each has their own discretion and they exercise it in their own way. So it becomes a bit of a problem when it comes to standardization of prosecution, because essentially there isn't any, just for that reason. Let's look at Connick versus Thompson. It's a case of someone 14 years on death row. Now this is a classic case of prosecutorial misconduct. Prosecutors must give any either exculpatory or potentially exculpatory evidence to the defense. Now this was a murder case. This person was looking at the death penalty. So the prosecutor decided not to give out certain information to the defense that they were required by law to give, both by the Constitution and by statute to give to the defense. The person was convicted, spent 14 years on death row, and then was later found to have been acquitted of the crime once the new evidence was discovered that had not been given over by the prosecutor. So now what happened is this person was, found not guilty of the crime once that evidence came out, and a new trial, of course, was ordered, and that new trial was given, and he got off, as he should have, because the evidence was there that made it so that people could never say that he had committed this murder. So the question then becomes, can we sue the prosecutor for a violation of law that put somebody in prison for 14 years? And the answer was yes. There was a suit in federal court for the violation of this person's constitutional rights to a fair trial, and he was awarded $1 million per year for the years that he was in prison. Okay, so this person was actually ready to be executed, could have been executed, by the way. 14 years on death row, could have been executed at any time. Luckily, it was on death row for long enough for the evidence to somehow leak out that that had been withheld. All right, so the question raised regarding DA's office paying for egregious prosecutorial misconduct, the answer is they should pay for it, and the DA that did that should be disbarred as an attorney, should be subject to probably possible criminal prosecution for violating the constitutional rights of that defendant as well. And of course, they should be individually sued, as well as the county agency that that they worked under should also be sued. And there you go. That's just a good example of the whole thing. So the U.S. Supreme Court overturned the jury's decision, arguing one cannot sue for civil rights violations under Section 1983, which is a section of the federal statutes that allows for suit against someone for a government related or something done under color of authority, where the government essentially violates someone's constitutional rights and allows for someone to sue that government official for violating their constitutional rights. And they said that they couldn't do it for a failure to train prosecutors based on a single Brady violation. Essentially, what probably happened here is that this might have been a mistake, in that it's possible this was not intentional, in the sense of we want to withhold this evidence because if they have the evidence, they'll get off. That wasn't maybe so much the issue as it was they did not know that they had to give it over in the first place. And a Brady violation means Brady is a case where the United States Supreme Court decided on this issue of the obligation of prosecutors to give over exculpatory or potentially exculpatory evidence to the defense immediately. Also, prosecutors are immune from civil lawsuits when they are performing their role, but only enjoy immunity outside the judicial arena, essentially where they give advice to police to do things, and anything outside of their role in actually prosecuting cases. If they're actually prosecuting a case or making a decision about prosecuting a case, or in the act of prosecuting a case, they're absolutely immune. And the reason for that is we don't want people to worry about being prosecuted when they're being sued when they're doing their prosecutorial role. But if they go outside that, started giving advice to police on what they can do and what they can't do, then we can nab them for giving faulty advice. But they just decided that you cannot sue the prosecutor's, government agency if it was simply a failure to train prosecutors on what their obligations were, and essentially it was basically a mistake. It wasn't an intentional act. Okay, let's look at courts, controversy, and gender equity. Are sexual assaults against women under-prosecuted? What do you think? The FBI does statistics on what's called the black number of law, the black figure of law. I mean, black figure of crime. And what that is they try to figure out how many cases are not even reported to police of all kinds. The way they do that is they literally go out and they pick, let's say, several thousand people randomly in certain urban areas, for instance, and then they go and they interview these people. They find how many people are willing to be interviewed, and they interview them about how many crimes have occurred that they were involved in, and how many of those got reported to police. And so what they do is they find how many have not been reported to police versus those that were reported, and then they start doing their statistical analysis, and they can start figuring out how many crimes should have been or that were actually reported per 100,000 people, let's say, and then they can actually come up with a figure in percentage of how many of the cases that are not reported compared to those that were reported. And sexual assault cases, it was something like 80% of sexual assault cases are never brought to police in the first place. They're never investigated. And obviously it's what's happened. The woman thinks that there's no basis for doing either. They don't know who sexually assaulted them, or they think that they won't be believed. So if you think that they are under-prosecuted, is the reason because criminal justice officials fail to adequately consider the plight of the victim, or because these cases are more likely to have evidence problems? Which is it, do you think? It might be a little bit of both. Might be a little bit of both. Because, by the way, these cases are very difficult to handle. They take a lot of resources. Police will investigate these things to the extremes, and then only rarely find cases that will ever end up being actually physically prosecuted in court by the prosecutor. And by the way, the prosecutors, when they take these cases, it was told to me in my first years of prosecution in California, we only win about 35% of the ones that we file, which is sort of unheard of, because our normal statistics are 97% conviction rates for most crimes. Well, this is 35%. And that's of the ones that we decide to take. That tells you nothing about the ones that were rejected. So the cops were, probably may not be as sympathetic to victims like this, because they can go through all these efforts and they will not get a case that won't do anything. And so, yes, there is a gender inequity going on, and especially sexual assaults against women, certainly. That's definitely the case. There's no doubt about it. The reasons are both because they're difficult to find evidence of them, and because there's a bit of a most people in law enforcement are male, and they're not quite as sympathetic as they perhaps should be with the plight of the victim. Okay, let's look at the dual court system. Federally, we have the Solicitor General represents the United States government before the United States Supreme Court in all appeals of federal criminal cases. They often appear as amicus in appeals involving state criminal convictions. Amicus just means a friend of the court. They can make arguments to state court state court cases to try to influence the court in a certain way. The criminal division federally it prosecutes a few nationally significant criminal cases and exercises nominal supervision over U.S. attorneys. The state usually starts out with the Attorney General. That is the head law enforcement officer for the state. They have civil duties also. They also have limited authority in criminal prosecutions. They can take over a case if they want to, but they typically leave all the cases to the county prosecutors otherwise. So the chief prosecutors and their assistants have great autonomy in prosecuting felony cases, typically argue cases on appeal as well. And so more typically you have county prosecutors, you have state prosecutors. County prosecutors do the vast majority of the work. And the Attorney General's office does sort of an overseeing role in criminal prosecutions. They will also take cases that a county prosecutor cannot take because of a conflict of interest. Also, U.S. attorneys and their assistants are the attorneys that do the actual prosecutions federally. We have local prosecutors that handle all versions of almost every criminal prosecutions in the state. All right, let's look at the U.S. Attorneys General. The three most important entities in prosecution are the Solicitor General, that's the third ranking officer in the Department of Justice. And then we have the Criminal Division of the Justice Department. It formulates criminal law enforcement policies in federal cases. And then we have the U.S. Attorneys. They are the principal litigator. They're actually the ones that go into court under the direction of the Attorney General. The Attorney General, of course, is an appointed position by the President. It's part of the executive branch of government. And they do the prosecutorial role for the federal government. Remember, the federal government is a system of limited jurisdiction. So they can only prosecute certain kinds of cases of criminal violations based on the fact that the federal government can only make certain things criminal. They must leave the rest of it to the states. Okay? So U.S. attorneys are appointed and serve at the discretion of the President with the consent of the Senate. So it'll be appointed by the President, but then they have to be okayed by the Senate before they become the Attorney General. And then the three statutory responsibilities are to prosecute criminal cases brought by the federal government, initiate and defense of civil cases in which the United States is a party, and then collection of certain debts owed the federal government. So they are sort of like the government attorneys. They do the government business in the terms of litigating cases in court. Okay, there's other attorneys like the Solicitor General that does very specialized versions of this, but the U.S. attorneys are essentially both civil and criminal prosecutors for the federal government. All right, what you might want to think about this, and that's researching the current U.S. Solicitor General. Go to this website; you can find out lots of information about them. And then what exactly do they do? What is their job function? What is it what's their mission? And how does someone qualify for this position? It would be a good idea just to figure that out. And spending a little bit of time like this can really help you just to learn a lot more about our system. And again, U.S. Solicitor General, it typically is involving cases in the higher courts, appeals to the higher courts. That's courts of appeal and the United States Supreme Court. All right, let's look at prosecution in the state. We have three overlapping entities. We have the State Attorneys General. We have who is the chief prosecutor. Or actually, the chief prosecutor would be whatever is the local prosecutor for that area. The local prosecutor is typically the city prosecutor or the one that's at a very lower level of prosecution. So what happens is the State Attorney General can take over any prosecution that they want to, but they typically leave it to the chief prosecutor and local prosecutor. In California, we have municipal prosecutors, that's a city prosecutor, and we have county prosecutors. And then, of course, we have the Attorney General that oversees everybody. But that is the hierarchy. What goes on in city prosecutors, they're allowed to prosecute only misdemeanor cases and only those that happen within the city, whereas the county prosecutor can prosecute any cases that happen within their county. Okay. All right. So let's look at another thinking point. What you look at your State Attorney General, the chief prosecutor, and the local prosecutor. See what the hierarchy is of your state prosecutors. You'll see that there are generally three different levels of them, as there are in California. And then who are they? And what do they do? What qualifies them for the position? Are they effective in their position? Do a little research and find out in your own state. It would help you to understand the prosecutorial role in your own state much, much better. All right, let's look at the prosecutor's office at work. Now let's look at assistant district attorneys. And in California, we call them deputy district attorneys, but it's the same thing. And also at the federal level, we have assistant United States attorneys that are essentially the attorneys that go into court and do the work. The actual, let's say, attorney general for the federal government is actually an elected official. You'll never see them going into court. They're managing the office, is what they're doing, and they're an appointed position. They're a political position. And the same is true for the local prosecutors. The district attorney, for instance, for the county, has a number of assistant district attorneys or deputy district attorneys, and they all go through litigating cases. Now, there is a high turnover in prosecutors' offices. The reason for that is that you get all of the trials you can eat, essentially, as a prosecutor. Trials are very stressful events. You're sometimes given, very, very responsible kind of cases where, someone has done some heinous acts of all kinds, and it's up to you and only you to put this whole case together and get the job done of actually putting on the evidence so that you have a chance of convicting someone that you really believe did the crime. Learning the job, it takes a considerable amount of time because it's not something that's taught in law school. There's very little exposure to actual day-to-day litigation responsibilities in law school. And so you have sort of a young prosecutor syndrome going on. And the young prosecutor syndrome is a situation where when people come into the office at first, they sort of think they have to go in and sort of aggressively prosecute every case. This actually happened to me as well. And that's why I got the nickname Captain Justice, because I kept going and wanting the right sentence on every case and willing to go to trial on every case, all that sort of thing. That's typical of a new prosecutor, and they haven't had time to develop essentially a sense of compassion and restraint that's necessary as a more seasoned prosecutor. And I remember a police officer telling me about the fact that after about 5 years on the police force, he finally felt he sort of knew when he needed to react to things and when he could let things go. When he saw things going on out there in the world. But when he was first in it, he would react to everything. Someone was doing something wrong, you got to go out and do something about it. Well, not necessarily. You got to use restraint sometimes because it's best for that purpose. It becomes basically it's based on experience. It takes time to get experience. And so this syndrome sort of rides roughshod over the courtroom work group and causes all sorts of grief for judges and defense attorneys, and then they'll give back to the prosecutor some grief as well because of it. So you can see how that can cause some problems. Then promotions and office structure. Experience usually leads to promotions. If you're a better prosecutor, we can trust you with more responsible cases. And if we trust you with more responsible cases and you do your work like you should, we want to promote you because we want to keep you around. We don't want to lose you, because if we lose you, what's going to happen? You're going to go to the civil courts and make money as a civil trial attorney and make a ton of money, a lot more money than you can make as a prosecutor. And we'll lose all that experience that we've taught you, so to speak, or that our system has taught you. Supervision is usually supervised by a section head. Each section head usually supervises some section of the. It could be, a section head would be whatever cases are filed in a certain court, or it could be certain types of felony cases, or whatever it is. It's entirely up to the office on how they want to break up the supervision. But there'll be a supervisor, because you can't just let these guys do whatever they feel like doing, and you have to watch over them to make sure they're doing things the way that the elected official wants things done. And there's also attempts at greater supervision that occur. We have to be very, very careful about supervising, especially the prosecutor, because they have such great and important duties to the community, to the legal system, to the Constitution, and so on. And the way they've attempted to have greater supervision is to create more policies, because frankly, you're given a caseload and you have essentially unfettered discretion on how you're going to deal with those cases. Well, it may be that the elected head law enforcement officer does not want to give you unfettered discretion. They want to have control over that discretion to some extent, and if they'll do that, they'll do it by policies. Office policies. You better not violate the office policies unless you have a very good reason. Otherwise, you can be disciplined for doing so. And so that's how they control and supervise more rather than less. All right, there's also representatives of both victims and the police. So the prosecutor, especially in California, with the Victims' Bill of Rights that was passed in 1982, there's actually a duty on the part of prosecutors to represent victims in a certain way. They don't actually, the victim is not their client, but they have to represent the victim in a certain way. So for instance, I would have to go in and get a restitution judgment for a victim. So I would have to represent the victim in the restitution hearing for the purpose of getting them a judgment for money that they're owed in restitution for the costs that they are out because of the crime. And we also represent police in the sense that we guide police in how to do their work. They'll come to us and say, hey, do you think this is legal? Can we do this? What do you think about this or that? Give us some guidance here. We want to make sure that what we're doing is legal. And so we will give them that guidance. We want them guided. We don't want them doing things that are illegal. You can lose good prosecutions because of just a mistake like that. All right, prosecutorial immunity. First of all, if it's anything that goes on in the true prosecutorial role, which is deciding on what cases should be filed, filing the cases, prosecuting the cases to decision, anything, or going through an appeal and so on, all those things, whatever is going on in that realm, the prosecutor is absolutely immune. You can't go after them for anything, no matter what. Okay, and the reason for that again is because if we place upon prosecutors some sort of possibility of being sued for what they do as prosecutors, we're gonna freeze them up in terms of wondering whether they should prosecute or not, and we don't want their discretion being frozen like that, worrying about their own financial problems, so to speak. But now they have qualified immunity, which means basically partial immunity when they're acting as an advocate for the government. So if they're trying to give the police good advice on what was going on, then even if it's wrong, they can be sued, generally speaking. Okay. And so you can see that the prosecutor, because of the power that's been given to the prosecutor to do all these things, the discretion that has been given to prosecutors in making these key decisions that will often make the difference in whether someone's life is, maybe all right or, is suffering a disaster, is all up to these prosecutors. So we then have to put very high ethical standards on what prosecutors do. So ethical issues are different from those facing defense attorneys. The client of the prosecutor is the government, essentially the people, but we have to make sure that they are just as interested in a fair trial for the defendant as convicting the defendant. And we have to make sure that there are no conflicts of interest that can get into the prosecutor's thought process. We want it to be completely unbiased and objective, and look at all the issues involved and make the right decision based on all those factors, not on the fact that they want to push one interest or another in going after somebody. Okay, so where ethics start coming into play are first disclosure of evidence. We want to make sure that prosecutors disclose pretty much everything. There are a few areas that they do not have to disclose, but beyond those, everything is disclosed and in a timely fashion. Because without that, you don't have a fair trial. If the prosecutors have evidence that the defense could use, it better be given to them, absent those very few areas where we allow them not to give up evidence, such as privilege evidence and so on. Conflict of interest, we want to make sure there is no conflict of interest. In fact, most policies, if they're not policies, they're required by law, that if you have an interest in a case, you know the victim, you know the witnesses, you know what happened, you have personal knowledge of the case, you have friendship with someone in the case other than the defendant, or even if you have friendships with the defendant, you cannot be making the decision on that case. You cannot have anything to do with that case. You need to be entirely off the case. There cannot be any conflict of interest. It has to be, the decision has to be made with someone who has absolutely no conflict of interest. And then the discretion. We want to make sure that prosecutors are using their discretion in a judicial fashion rather than just going after people because they can and there's a case there. Not every case should be prosecuted. And that discretion needs to be used in a judicial manner and not just every case. They have to make some decisions on what cases should be prosecuted, and it's based on what they think the community needs. Okay? How much information to release to the public is another issue, because when we release too much information to the public, we might very well find out that we can't find an impartial jury to give a fair trial to the defendant, and that can cause lots of grief, as you might imagine. All right, key developments regarding the prosecutor versus Berger v. United States. That's the prosecutor's primary interest in doing justice, not simply winning cases. So this places upon prosecutors the duty to do justice, whatever that means, but not just winning cases. So doing justice might not be winning a case, may not even be filing a case, but the primary interest of the prosecutor must be doing justice. And so they'll be judged based on that standard. And justice also requires a fair trial if there is going to be a filing. Imbler versus Pachman, that tells us that prosecutors enjoy absolute immunity from civil prosecution when initiating and pursuing a criminal prosecution. If they're involved in that role and that role only, you can't go after them no matter what they do. Even if what they're doing is malicious, even if it's done without sufficient evidence, you can't go after them. I know, and it sounds like that's not a good idea, but you know what? If we have it any other way, prosecutors will be wondering whether they're going to get sued or not. We just don't want them wondering, because we want their discretion to be unfettered by that kind of concern. All right, Morrison versus Olson. Independent counsel law is constitutional. Burns versus Reed. Prosecutors enjoy only qualified immunity from lawsuits concerning advice given to the police. That makes total sense. Buckley versus Fitzsimmons. Prosecutors enjoy only qualified immunity from lawsuits for actions during criminal investigations and statements made during news conferences. So if they make statements about somebody, and they defame them with false information, whether they think it's true or not, they can be sued. You've got to be very careful what they say in news conferences. And also, if they're involved in a criminal investigation, and they often are, because prosecutors also have investigators, and they go out and investigate. If they do something illegal, the prosecutor can be sued. Colino versus Fletcher. The prosecutor may be sued for making false statements of fact in an affidavit in support of an arrest warrant. Most certainly. Now that usually takes it takes some sort of culpability there. It has to at least be negligence and or knowledge that it's false. But it certainly can be true because again, if you're dealing with an arrest warrant, the person hasn't been arrested yet. They're not. There has been no filing, and they're not involved in the filing of a case. So the prosecutor's outside of their absolute immunity. Connick versus Thompson. A district attorney's office may not be held liable under Section 1983 for failure to train prosecutors based on a single Brady violation or perhaps even a handful of Brady violations. Essentially, if you just didn't train prosecutors well and they made a mistake rather than an intentionally wrongful act, then that's not enough to sue them for it, because again, they're involved in their prosecutorial role. Let's look at the Casey Anthony case. What issues did you see in that prosecution? There were a lot of them, as you might imagine. What could the prosecution have done differently? Think about that case, and then put yourself into the position of a prosecutor, and see whether you think mistakes were made or not in that case, and if so, what kind of mistakes were made. And then see how it actually came out, and when you do your research to look at the case again. Because people have done a lot of research about the case. They've done a lot of writing about the case. It's all out there and available to you. It'd be a good thing to do just to get yourself thinking about that position as a prosecutor in a real case that actually happened. Let's look at the prosecutors in the courtroom work groups. Again, there are conflicting goals and contrasting work groups, but prosecutors have different goals than the defense attorney. The judge has a different goal than either the prosecutor or the defense attorney. But again, they have to work together and they're interdependent, so they do have to work together. Now we have contrasting work groups. This can happen even between different judges in the same court system. And so you may have to work differently in one work group with one judge versus another, depending upon what case you may be working on as a prosecutor. The political styles and contrasting work groups, again, there's a socialization process that goes on. You will have to learn, I call them personalities and procedures. Essentially, what are the personalities of the people involved? That's one thing you want to learn. And next is what kind of procedures are required by this informal work group. You need to know those things before you can use them to foster your best interest in doing your job like you're supposed to do and getting the most effectiveness out of the time you're spending on doing your work. All right, let's look at the expanding domain of the prosecutor. One thing that's going on is there has been an improvement in the police-prosecutorial relationships. You would think they're often walking in lockstep with each other, but that's not necessarily the case. Police want their work to end up being fruitful, and what fruitful to them means not just an arrest, but also a conviction and someone being appropriately sentenced for the bad things that they did. And so they have to work with the prosecutors, but the police are usually under a lot of pressure to catch the perpetrator of some heinous crime that has taken place. And so they will sometimes you bring in a case that's very marginal, and the prosecutor might say, you know what, there's no way I'm filing this case. I will not win. All it's going to do is waste my time, waste your time, waste the court's time, and we're going to end up letting this guy go anyway. You don't have a case? I can't prosecute your case. Police are saying, wait a minute, this is the guy who did it. Well, give me some evidence and maybe I'll prosecute him. You can see that the possibility that the relationship can be at odds with each other. Remember, the police are under pressure to get this person and get the right person, get him prosecuted, get justice dispensed. That requires the prosecutor to go in to court on the case that is investigated by police. Typically, you don't see prosecutors out investigating criminal cases originally. It's the police that do that, police or sheriffs. And so they're the ones that are under the gun. They're the ones that the media is going all over the place, putting pressure on them to find the right person and get them in to get them prosecuted. And then there's community prosecution. The idea for that is crime prevention is the goal, and so they look at things quite differently than the punishment mode that we see for adult criminal prosecution. Well, let's look at close up on Burns versus Reed, and that brings up this question. Let's go back to Burns versus Reed back here, because if you look at Burns versus Reed and what it meant, let's see where it is here. There it is. Prosecutors enjoy only qualified immunity from lawsuits concerning advice given to the police. Okay, so should there be any immunity for prosecutors who are out there giving advice to police? They may give them the wrong advice. They may say something is legal and turns out it is not legal. What happens when that goes on? Should the prosecutors be sued along with police? And maybe should the police actually be absolved of liability because they relied on the prosecutor? Maybe it should just be the prosecutor who has the liability because they're the ones who gave the advice and it was wrong. So look up that case, by the way, and see what the Supreme Court said about the reasons behind this. And again, if we did not have at least some immunity for prosecutors in giving advice to police, they probably would not give advice to police. And that's a fact. Why? Because they don't want to get sued. So we probably need some immunity, because if we don't have it, then police will not be properly guided by attorneys whose job it has always been to know what is legal and what is not legal in terms of what the executive branch of the government can do in a criminal context. All right, so actually look up the case and see what the Supreme Court said about how they justified that there should be some immunity for for prosecutors in that situation. All right. All right, that's the end of chapter 6. Again, if you have any questions, any concerns regarding the learning of this chapter, please feel free to give me a call or email me, and I'll be more than glad to help.